part of this CLA webinar on regulation of the legal profession in the times of COVID. We have a disparate geographically set of panelists who I am absolutely confident will provide a really great session for us. Let me introduce myself. I am Brian Spears, and I am the president of the Commonwealth Lawyers Association. The CLA is a body that represents individual lawyers, law societies, and bar associations in the 54 members of the Commonwealth, who by and large all share a history and a common law and make a family of independent countries, but with much to unify them. I was appointed as president in April of 2019 at the Commonwealth Law Conference in Livingstone, Zambia. And I'm delighted to say that our next conference will be in Nassau, the Bahamas, in September 2021. And those of you with an interest in broadening your horizons beyond your own jurisdiction would find a very friendly welcome in the Commonwealth family attending that conference. This seminar is entitled Regulating the Legal Profession, and is one of a series of events that the CLA have organized and is part of our role to educate, inform, support, and encourage members, while at all times upholding the rule of law. Yesterday, I participated in an event with one of our panelists organized by the Southern Africa Development Association or Lawyers Association on the question of rule of law and an independent legal profession. And I do think that when regulating the profession, there is something about maintaining independence, and that might emerge during our panelists' remarks. Today, I'm speaking to you from Belfast, but we have panelists from Toronto, from Kuala Lumpur, and I imagine from South Africa, where Stanley is, and David Lavery is also from Belfast, and I will introduce them all to you as their slot appears on my running order. I recall from yesterday that one of the speakers spoke of the need for lawyers not just to expect the rule of law to apply to politicians or people in business or people in executive authority, but also the rule of law applies to lawyers. And that requires us to maintain standards to uphold our professional integrity, our duty as officers of the court. And it's interesting to reflect that we too have a responsibility. And in some jurisdictions, regulation is being used by governments to seek to control and manage the legal profession. And actually the strategy is to seek not an independent profession, but a compliant profession. And with those thoughts, by way of introductory remarks, I simply address the theme of this conference. If we are acknowledging the benefit of an independent legal profession, how is it to be regulated? Well, that's not this seminar. That is a seminar in its own right, and most interesting, I imagine. We are presently regulated, and how have the regulation of our professions in our different jurisdictions coped during a global health crisis, where we're all affected in the same way. We all have to maintain distancing, we have to avoid contact. How have the regulators coped? So our panelists today are Teresa Donnelly, the Treasurer of the Law Society of Ontario, Stanley Nyamanhi, the Chief Executive Officer of SADC Lawyers Association, and a lawyer originally hailing from Zimbabwe, David Lavery, the Chief Executive of the Law Society of Northern Ireland, and Stephen Tiru, the Vice President for the Asia Sub-Hub, or the Asia Hub of the Commonwealth Lawyers Association, and a former President of the Law Society of Malaysia. So with those introduction remarks, let me tell you what we hope is going to happen. I will give each of our panelists approximately 10, but no more than 12 minutes. They can set out some thoughts on regulating the profession in these COVID times. I will then bring their session to a close and move on to the next. And I hope that after everybody keeps to time, we will have some time for questions or comments. But I suppose that's down to me. And I'm going to ask Teresa Donnelly to commence. Teresa is the Treasurer of the Law Society of Ontario, where she was elected in June of 2020. She graduated from the University of Ontario and was called to the bar in Ontario in 1991. I'm told that Teresa has dedicated her career to justice for the victims of domestic and sexual violence, and has served on many committees within her law society, and indeed is on the faculty of the National Criminal Law Programme of the Federation of Law Societies in Canada. As the top elected official of the largest law society in Canada, she presides over the body which regulates Ontario's lawyers and paralegals. Teresa, over to you.
Thank you. I wish to start by recognizing that I am in Toronto, Ontario. Toronto is a Mohawk word that means where there are trees standing in the water. I say this in the spirit of reconciliation and importance of reminding all of us that we share this land with one another and with Indigenous peoples. I would like to acknowledge that Toronto is on the traditional territory of the Mississaugas of the Credit First Nation, and acknowledge the Haudenosaunee and the long history of all the First Nations in Ontario and the Métis and Inuit peoples. In relation to the effects of the pandemic, in Canada, we are fortunate to live in a country that has a solid socioeconomic footing, where we have access to free public health care and different levels of government social benefit infrastructure, which provided support and financial relief to Canadians who needed it during the pandemic. I will speak to the experience that we've had in the province of Ontario in relation to regulating lawyers and paralegals. Canada has 14 provincial and territorial law societies. The Law Society of Ontario is the largest, with more than 55,000 lawyers and close to 10,000 paralegal members. The province of Ontario went into lockdown in mid-March. With the exception of urgent family and some criminal matters, all court proceedings were suspended March 16, 2020. In early July, courts began hearing more matters, but have not returned to full capacity pre-pandemic. When Ontario went into lockdown, the Law Society had to respond and to move swiftly in ways we never imagined. Our core mandate is to govern in the public interest, and our main priority throughout this time was to fulfill our mandate. I believe that we've achieved that with minimal disruption. The Government of Ontario deemed law offices and paralegal offices as essential workplaces. As such, law offices and paralegal offices were permitted to remain open. The Law Society of Ontario implemented a successful work-at-home plan for its own employees and encouraged all law offices and paralegal offices to do the same by operating remotely and virtually wherever feasible. While the Law Society of Ontario has had to respond to many issues and challenges, I don't think that how we responded was with a light touch, which could jeopardize the public interest, but rather, I think we responded with a different touch. I will highlight some of the key measures and strategies the Law Society of Ontario has taken to ensure that we continue to effectively regulate in the public interest and to support our members. Much of our effort and a key strategy was to ensure that we stayed connected with licensees and provided them with the information and resources they needed to support their practice and to navigate through the challenges of the pandemic. The Law Society created a COVID-19 online resource center with information and resources for licensees and members of the public. The message on the Resource Center for lawyers and paralegals in the context of the pandemic was that in this unprecedented situation, some flexibility may be required to ensure continuity of essential legal services without undue risk to public health. We acknowledge that public health agencies have recommended a number of measures to reduce the risk of transmission, including social distancing. We recognized, however, that many legislative requirements and risk management measures require in-person contact with clients and others. We posted answers to frequently asked questions to assist lawyers and paralegals with alternative approaches to discharging competing duties. The Law Society's COVID-19 web pages have had over 1 million visits since March, with equal numbers of impressions on social media channels. The practice management COVID-19 frequently asked questions posted on the website included topics such as licensee supports, office management, practice interruptions, virtual meetings, client identification and verification, commissioning and notarization, signing documents, cybersecurity. Other information was developed about trust accounting and bookkeeping. Let me give you one specific example of how the Law Society dealt with client identification and client verification. We took the position that the applicable bylaw continued to apply, but advised on our website that, quote, as a result of COVID-19, until further notice, the Law Society will interpret the requirement that lawyers and paralegals verify the identity of their client face-to-face as not requiring the lawyer or paralegal to be in the physical presence of the client. Rather, alternative means of verification, such as face-to-face verification via video conference, will be permitted, close quote. We advise that nonetheless, lawyers and paralegals should conduct a risk assessment to ensure that it is appropriate in their circumstances to verify identity via video conference. In addition, we sent weekly updates to licensees to ensure that they were informed and to point to resources to help them manage and stay connected. We've provided supports to our members who had specific questions through the existing practice management helpline, which is a confidential service that addresses lawyer and paralegal questions about rules and practice management issues. In Ontario, we have mandatory continuing professional development of 12 hours a year. To assist members in fulfilling this requirement, archive programs were made freely available, as were programs developed in response to COVID-19 issues. By the end of March, the programs were online. Some of the new programs developed for COVID-19 include how to run a home-based practice, conducting a paperless hearing in family law, the intersection between health and well-being and your litigation practice, and mindfulness at work, a workshop for legal professionals. While annual fees were payable at the beginning of March, in recognition of the challenges faced by some licensees who had not yet paid, we deferred the payment of fees for a period of time. The federal and provincial government provided programs to provide for financial relief, and the Law Society advocated to ensure that the needs of lawyers and paralegals were addressed or considered. As the pandemic created uncertainty, change, stress, and health concerns for our members, we continue to advise our members that the Law Society provides access to assistance through our confidential member assistance program, which offers counseling and other resources to licensees. The pandemic affected future lawyers and paralegals as well, those in the licensing streams. Well, we've been considering for a long time moving to online examinations. When the pandemic hit, we had to do it. We transitioned from large venue in-person exams with thousands of new lawyers and paralegals and moved to online, with the first exams being held in June. Licensing examinations for online were shortened from 7 hours to 4 hours. We also reduced the experiential training portion from 10 hours to 8 hours for lawyers. In regard to regulation of lawyers and paralegals, 3 types of practice audits are used. And the audit program is designed as a proactive compliance, measurement, and problem detection tool to assess ongoing compliance with record-keeping requirements, the rules of professional conduct, and to identify serious misconduct related to financial matters. The primary goal is to identify and correct minor deficiencies before they lead to serious non-compliance or misconduct issues. Similarly, a practice management review program focuses on quality assurance in service of the public interest. The program is proactive and preventative, and it's designed to support lawyers to be efficient, effective, and competent. These practice audits were significantly impacted by the emergency state and the inability to directly engage at places of business of licensees. So the Law Society developed criteria and protocols for conducting fully remote audits, and we transitioned from an on-the-ground audit program to a remote audit program using video conferencing and document sharing technology. The remote audit focuses on financial areas that have been identified as a higher risk to the public. The process has just been implemented, and we expect to complete approximately 100 lawyer practice reviews and 40 paralegal audits. For our complaints and discipline process, the levels have remained steady over the past 6 months. Processes were modified to ensure that there were no or minimal disruption in service as a result of the transition to working remotely. Complaint files can be very complex, and much of the procedure is paper-based, so we had to create new processes and protocols. The Law Society Tribunal is an independent adjudicated tribunal within the Law Society of Ontario that hears matters for regulatory cases for Ontario lawyers and paralegals. All matters before the Law Society Tribunal are currently being held electronically, with hearings being held by video conference using the Zoom platform. To better serve the public, in family law cases with courts, we developed an emergency family law telephone referral line that connects self-represented litigants with family law lawyers working on a pro bono basis who will provide 30 minutes of free legal advice. In Ontario, the professions, together with stakeholders and justice partners, have responded to this extraordinary event with collegiality, collaboration, innovation, and ingenuity. COVID-19 has forced regulators to modernize and adapt and rethink what is effective and how do we effectively regulate. Our challenge in the years and months ahead will be to ensure that we leverage all that we've learned to continue to work with our justice partners to support the professions and to continue to fulfill our core mandate to regulate in the public interest, not with a lighter touch, but with a different touch. Thank you.
Well, really fascinating, Teresa. You've got us off to a brilliant start. You have kept to time, and thank you so much. I love the notion of effectively regulating with a different touch, and I'm sure that will be one of the thoughts that I will take away from this webinar today. We greatly appreciate your comments and the thoughtfulness that clearly has gone into assembling those thoughts, and speaking personally, I have got very much from that. You were good enough to recognize, Teresa, that of course your jurisdiction is financially able, is a mature and settled democracy, and that may make a difference. And I just wonder, does it make a difference as we turn to our next speaker, who is Stanley Nyamanhi. And as I have said, Stanley is the Chief Executive Officer of SADC Lawyers Association, which is the Southern Africa Development Corporation Lawyers Association. And this brings together 15 jurisdictions, I think I'm right, Stanley, in Southern Africa, mostly, but not all, Commonwealth members. SADC LA is the authoritative and representative voice of the collective legal profession in that region, supporting lawyers through interventions, programs, conferences. Indeed, I recall being honored to have received an invitation from Stanley to speak at a SADC LA conference in Botswana about 3 years ago, and have very fond memories of the connections I made with SADC then. And Stanley is originally from Zimbabwe, a lawyer there who has experience of working in the Law Society of Zimbabwe with particular interest in continuing professional development and practice development. Stanley, it's great to see you. Thank you for arranging the magnificent webinar yesterday on independence of the legal profession and the rule of law in your jurisdiction. And we would love to hear your thoughts on regulating the legal profession in the pandemic, and the floor is yours.
Thank you very much, Brian, and to the organizers from the CLA for this invitation. And like you rightly pointed out, we held yesterday a webinar for the SADC region and the African continent at large to look into issues of independence of the legal profession as against a recent wave of attacks that we noticed against individual legal practitioners, but also the regulatory bodies. And as I move into the contrast, one of the key messages that we got yesterday was that self-regulation is not in itself an end, but it is a means. And it is a means simply because the legal profession is a client-centered public calling, and the most important duty we owe is to the public. In that respect, the rule of law, when we talk about self-regulation and independence of the profession, is something that we aspire to achieve on behalf of the masses who rely on our expertise and on our duty to our constitutions to ensure that they enjoy their civil and political liberties. So in this instance, when I contrast with what the previous speaker has just said, you will note that we are in a developing part of the world, and certainly democracy is an evolving concept. Now, the coming in of the emergency under the COVID-19 pandemic resulted in so many governments taking the opportunity and failing to resist almost the temptation to promulgate legislation without going through it in a legal way, in many cases on an emergency basis, but which restricted so many of our liberties. And obviously, social support to members of the citizens was not something that many of the countries were ready to work with. You know, this part of the country is already struggling with sovereign debt issues, and coming up with extra funds to support just citizens was a challenge. It was a bit of a different issue in South Africa where I am, and there's a wider capacity and a more coordinated ability of the government to control the issues, but certainly there were challenges in that respect, and the legal profession was not spared. Now, Teresa referred to essential services within the legal profession. Here we noted that the whole of the legal profession was accorded non-essential service status, obviously in preference to the public health emergency that was being experienced, but that meant that those essential services that legal practitioners could provide and should provide were not given space to operate. And we found that it became a challenge in so much as regulation is concerned, because so many of the services that lawyers had in many cases been paid for just before the lockdown could no longer be delivered within lockdown. It led in some of the law societies, I was speaking to the Law Society of Lesotho, in a spike in complaints from members of the public for cases of non-delivery. And obviously set against the background of economic development is the issue of Wi-Fi, data, penetration of the bandwidth. Small issues like that became an issue because trying to run a hearing, a court case, you would spend the whole day trying to say, my lord, what was your last statement? And this became some of the issues that had to be dealt with. And obviously the rules of taking electronic evidence change, where the ministry in some cases, or the legislature in some cases has not yet provided so far into the future. And many of the law societies I talked to in handling complaints realized that they have not fully automated their systems. They are not totally paperless. And so the issue of receiving complaints became subject to the quarantine processes. If you received a package from somebody, it had to be in the quarantine inbox for a longer period. And yet, in terms of the rules of regulation, when a complaint is actually lodged, within 2 weeks, a legal practitioner is expected to respond. And the law society is expected to also give a response copying all the parties. And so some of these rules had to be changed. Now, one of the issues that I noted is this debate that comes in on self-regulation, where there is a debate on whether law societies should themselves be regulators of the profession. The talk of whether you can set dogs or bulldogs to police the other bulldogs. And in this case, we have noted at least 2 cases in which governments during lockdown came up with alternative bills to replace the the law society as the regulator. And what I noted is the issue that it is not a bad thing per se. We accept that the law society must be open to probity and accountability, but there have been political reasons underlying this, and this is what has worried us. So this change from regulation by the law societies to some statutory bodies that are being replaced through legislative attacks through parliament concerned us. I've got a few minutes left. I'm just going to run down some of the issues. Now, I looked at some of the law societies in reacting to the COVID-19 pandemic. In South Africa, it has been possible for the Legal Practice Council to offer a grant of 5,000 rands to legal practitioners who are paid up in order to get relief. But in most of the cases, when I looked at Zimbabwe, it was an issue of inability to give that sort of advancement or to reduce the amount for subscriptions for your license, but rather they would say you can pay in installments. And then they generated an automated system through which from a remote section, they could actually issue you a temporary licensing certificate for the period for which your installment is going to last. And it tended to ease out some of the challenges that were experienced. And yet in other cases, the law society just had to say, like in Lesotho or Eswatini, well, we were supposed to pay by March, now you can pay by August, so that at least they've got more time to find this money. Experiential learning had to stop in most of the cases because, like I said, the issue of online or virtual training was not something that had been anticipated. Some of the assessing panels would need to sit with the candidates face to face, and the rules had not changed. And obviously, I noted that some of the law societies reduced the threshold for continuous professional development points from maybe 12 to 6, and they also adjusted the credits that were attached to the courses, but definitely they accredited a wider number of courses, like the conference that we held as SADC lawyers yesterday. For attending, they would recognize it and give some points to some of their lawyers. So by and large, these are some of the key issues that came up, but the biggest issue, as I conclude in conclusion, was the fact that the restrictions around COVID made it very hard for us as a legal profession to push back on all of these regulatory constraints. And you find that a lot of the excesses by the police, in essence, were responsible for attacks on individual legal practitioners. Physical bar from getting into town to go to work because your practicing certificate is not recognized as giving you access to essential services, and physical bar from getting into the court. I think yesterday we had a specific example of a lawyer who the court barred from representing one client, but when she was going to the court to try to represent other clients, the police interpreted that to mean that she's persona non grata from the courts, and this therefore shows that excess is on the part of the security services, and securitization of the interpretation of regulations around COVID-19 pandemic created a huge challenge for the independence of the legal profession in our region. I thank you, Brian.
Well, I thank you, Stanley. I think it does us all good, those listening currently and those who will watch the recording, to see that in many jurisdictions within the Commonwealth, we are fortunate to have received some measure of government or law society support, that there is a designation that lawyers should be regarded as essential services. And it is both humbling but informative and important to hear, Stanley, from you about jurisdictions where what I might take as for granted is not the norm at all. And I pay personal tribute to you and your leadership of the region in calling out the excesses of government, the charade of legislative change within an emergency, which has a political agenda. And I love your expression at the start, Stanley, where you said that governments failed to resist the temptation to legislate. That's another takeaway for me from this particular webinar. And I think that we must all, and the CLA absolutely stands in solidarity with your colleagues in your region, and we must all help to call out political interference which affects the independence of the lawyers, so important for a modern democracy aspiring to be one that upholds the rule of law. So thank you very much indeed, Stanley. We are being very well behaved so far, and people are keeping to time. We'll see how we get on with our next contributor. And our next contributor is in fact David Lavery, CB, who graduated in law from Queen's University, Belfast, and then took a master's in law from Harvard Law School, where he served as an associate in Harvard's Center for International Affairs. After some time in private practice, he spent most of his career in public sector work, and mostly in the justice system in Northern Ireland. He has been the chief executive of the Courts and Tribunals Service in Northern Ireland. He has perhaps most recently served as Deputy Permanent Secretary in the Department of Justice, and he spent an interesting 3 years as Principal Private Secretary to the First Minister for Northern Ireland in an early version of our devolved government here. In 2019, he was appointed as the Chief Executive of the Law Society of Northern Ireland, and he has just completed his first year, where most of the last 6 or 7 months has been spent obviously in guiding the profession here in coping with the pandemic. As an Eisenhower Fellow, David is also distinguished for having been appointed a Companion of the Order of Bath in 2008. David, from a Northern Ireland perspective, we look forward to your take on regulating the legal profession in the pandemic. Thank you.
Thank you, Brian, and I look forward to hearing from Stephen shortly. I've really enjoyed Teresa and Stanley's contributions as well. So I welcome the opportunity to participate in the webinar in order to share experience as regulators and to learn from each other about aspects of best practice. I might begin by saying something about the Law Society in Northern Ireland, where we are the professional body for the solicitor profession. We have just over 5,500 members in our society, of whom almost 3,000 hold practicing certificates, authorising them to practice as solicitors, whether in private practice, public service, or in the corporate and voluntary sectors. The Society has 4 distinct responsibilities, and our organisational structure reflects these. We have organised the Society recently into 4 departments. Firstly, a professional development department responsible for the training and admission of solicitors and for their lifelong learning through a programme of continuing professional development. Our professional conduct department discharges our responsibilities as the regulator of the solicitor profession in Northern Ireland. We're also a member services organisation, and we have a member services department which provides a range of professional services in support of our members. And fourthly, we have a policy and engagement department which represents the profession in our dealings with government and wider society. In Northern Ireland, we went into the pandemic lockdown at the end of March, under which everyone had to stay at home for a number of months in order to contain the spread of the virus. And our courts and tribunals also closed at that point. Fortunately, the Law Society's IT systems, which we had replaced at the beginning of the year, supported working from home. And we supplied all our staff with laptops to support this new way of working. We have also introduced internet telephony so that all of our staff are contactable, whether working in the office or working from home. Although our staff have now returned to the office from the beginning of September, many still choose to work from home for at least part of the week. So far, I've not detected any falling off in staff effectiveness because of this new way of working, and I expect that it will now form part of what we are increasingly calling the new normal. We have been very aware of the impact of the pandemic on our profession, with many firms facing a dramatic and immediate interruption in their work. In order to better understand this, we undertook a survey of all of our member firms during the month of May. The results of the survey indicated that almost all firms had seen a very significant reduction in their turnover, and many were having to reduce staff costs in order to make ends meet. In response to these immediate challenges, the Society introduced a general financial support package to assist firms with cash flow. One of the initiatives we took was to refund 50% of the annual practicing certificate fee paid by every solicitor. The fee for this year was £1,300, and every solicitor has received half of this fee back, together with a refund of their contribution to the Society's compensation fund. This means that most solicitors have received £800 back from the Society. This, together with a number of other initiatives, have cost the Society £1.7 million from our reserves. Another business support measure was to make our programme of continuing professional development cost-free to our members this year. In Northern Ireland, each solicitor has to complete a minimum of 15 hours of professional development each year. By waiving these charges and moving the teaching online, this was another practical way of supporting our members. We are now planning to undertake a further comprehensive survey of our member firms next month in order to help us to understand how they have emerged from the lockdown and to identify any areas where additional support may be required. In addition to our financial support for our members, we've also been the principal communication channel between government and the profession. Both the United Kingdom government and the Northern Ireland Executive have introduced a range of business support initiatives in response to the pandemic. We have been issuing weekly updates to our members explaining where these new initiatives may have a part to play in supporting our law firms. We have also lobbied government on behalf of our members where they were encountering difficulties. An example of this was our success in lobbying the government to reopen the land registry. At the start of the lockdown, the registry had closed and had not made any provision for emergency applications. We coordinated a successful campaign with the Northern Ireland chapter of the Confederation of British Industry to explain to government the vital role that the registry plays in commercial lending, as well as in the areas of domestic and commercial conveyancing. This campaign was successful and arrangements were soon made to reopen the land registry for business. Turning now to our work as a regulator of the profession. In the Law Society, we recognise that our effectiveness as a regulator will be critical to our ability to retain our position as a self-regulating professional body. We of course know that independent regulation has already replaced self-regulation in England and Wales, and our neighbouring jurisdictions in Ireland and Scotland appear to be heading in the same way. We want to be ready to resist any similar moves in Northern Ireland. Much of our work in the next year or so will be concentrated on improving our effectiveness as a regulator. Although the pandemic has undoubtedly brought its challenges in this regard, in some respects it has in fact allowed us to accelerate the pace of change and to introduce new and innovative ways of working. Before lockdown, our regulatory model was very much based on inspections carried out on site at the offices of solicitor firms. This undoubtedly had its advantages, as an experienced inspector could almost sniff out the weaknesses in a firm's systems and processes. Once the lockdown occurred, however, the programme of inspection visits had to be stopped in its tracks. In its place, we've introduced a new inspection model involving risk-based desk reviews. Whereas in the past, we would have planned a rolling programme of inspections with the intention of periodically inspecting every solicitor practice at least once every few years, we now place much greater emphasis on a risk-based approach. Our work as a supervisory authority for the purposes of anti-money laundering and counter-terrorist financing compliance has helped us to develop a detailed risk profile of our member firms. And this has in turn allowed us to pivot our regulatory inspection activity away from a programme of cyclical inspections and instead to concentrate our resources on those firms with a higher risk profile. Of course, I would be the first to concede that a system of risk-based regulation is only ever going to be as good as the intelligence we hold on our members. Therefore, we've been placing a lot of emphasis on improving the information we hold on member firms and on our ability to analyse this information in order to drive our regulatory activity. Like so many of the changes that have been introduced during the lockdown, I believe that this new risk-based approach to our regulatory activity is almost certainly here to stay. I cannot really see us ever relying exclusively on a cycle of inspection visits in the future. Instead, I expect that our work in this area will place much greater reliance on intelligence gathering, data capture, and data analysis. The challenge we have in successfully embedding this new approach will be to ensure that we have the right skills in our regulatory team to fully utilise a risk-based approach to our work. In conclusion, I'd like to say that in time, I hope that our members will come to recognise and value the benefit of being part of a well-regulated profession which has adapted to changing circumstances. I would like that, in fact, they would come to appreciate that our regulatory work is not something that the Law Society does to them, but rather it is something that we do for them, and which improves our standing as a profession in the eyes of government and the public at large. President, that concludes my initial observations, and I look forward to responding to any questions later in the webinar.
Thank you very much, David. Again, concise but dense with information and insight, and the risk-based regulatory approach and the intelligence gathering, I think is potentially, although we might explore this in our questions, one of the enduring legacies of the change to what Teresa has called the different touch. And I very much support the idea that across the Commonwealth, we should be, as practitioners, willing to be effectively regulated in order to give the profession at large confidence and to wear, if you like, the badge of being a lawyer with confidence. Now, Stephen has been waiting patiently, I hope, and it's my pleasure now to turn to him and to receive his contribution. Stephen is the managing partner in Stephen Tiru and Sudha partnership in Kuala Lumpur, Malaysia. He's a senior litigation lawyer with a wide civil litigation practice and an especial interest in issues to do with native title and indigenous peoples' land rights. Indeed, Stephen and I and some Canadian colleagues and colleagues from Australia are embarking on a project within the CLA broadly entitled The Land Rights of the Indigenous Peoples. And Stephen read law in England at the University of Leicester. He was admitted to the bar in England and Wales, and then the Malaysian Bar. He was a president of the Malaysian Bar in 2015 and 2016, a time I recall of some turbulence in Malaysia. And Stephen served his profession as president, not only with distinction, but also with considerable bravery. And I recall very much Stephen's presiding in Malaysia at a very difficult time there. He's involved in the executive committee of Law Asia, which involves lawyers in the extensive Asian region. And he's also on the executive committee of the Commonwealth Lawyers Association. At our conference in Zambia in April 2019, Stephen was elected vice president of the CLA Australasian Hub, a vast hub geographically, from India to the Pacific Islands. And all this, Stephen, under your remit and subject to your exemplary leadership. With your background as a practitioner and a Bar Council leader, we hand the floor to you for your reflections on regulating the profession in a pandemic.
Thank you very much, Brian. Distinguished panel members and ladies and gentlemen for watching us online. I seek to give you a perspective and perhaps context of my country, Malaysia, and also a bit about what's been happening in the larger Australasia region that Brian has mentioned. I have the benefit of information because we've had webinars and we've consulted our colleagues in the Australasia region, and you'll find that together with Malaysia, we have all been struggling to cope with this, with the impact of the COVID-19 pandemic. In Malaysia, sometime in March this year and up to May, we had different degrees of restrictions on movement. It was really a de facto nationwide lockdown. And in that 2 months, in what is called the movement control order, our law firms came, well, they could not fully operate. The courts were closed except for limited criminal matters and online hearings, and only online hearings on simple matters as like fixing of trial dates. And really the upshot of all that is this: legal practice is so severely affected, and the administration of justice practically came to a grinding halt. And one of the reasons for that is, I think it was mentioned by one of the speakers before this, that law firms and the courts were not in my country designated as essential services. The regulator in Malaysia is the Bar Council of Malaysia. And the Bar Council is a body established under the Legal Profession Act, 1976, so it's a creature of statute. And the Bar Council regulates today 20,000 private practitioners in a population of 35 million and over about 6,000 private law firms. When the pandemic hit, and of course it was not something that anybody was prepared for in any sense, the Bar put in place a number of raft of measures to cushion the impact, and indeed the financial impact of the pandemic on the profession. And hearing my colleagues before this, I can see a lot of commonalities in the approaches and the challenges. I today want to focus on two particular areas in the limited time that I have. And the two particular areas are the training protocols that we have adopted and put in place for our our new entrants to the profession, our pupils and lawyers, and aspects of financial assistance that we have seen, both in Malaysia as well as in other countries within the Australasia region. In Malaysia, and I think this is a common feature in many other countries in the Commonwealth, every intending entrant the bar is required to undergo pupillage. And that's 9 months under a lawyer of not less than 7 years standing. And there's really no textbook on this. It's really the old school, unarticulated way of training a junior person. And it's very hands-on and a very personal sort of experience. And we always tell our pupils, what you get out of pupillage is actually what you put into it. Now, one of the things that we emphasize with pupillage is that 9 months must be continuous, because we are, of course, are conscious that 9 months is not very long, and there's a lot in the transition from a person who has just finished academic and practical training and then to be considered a full-fledged lawyer. So we require that 9 months to be continuous. And you can imagine, of course, when the pandemic hit and you had the lockdown, the entire training for that period, at least for 2 months or so, was interrupted. So the burning question for the bar was whether or not we would require them to do a further extension to the 9 months to compensate for the loss of time. The bar took the position that we would not do that simply because of the fact that law firms, despite the shutdown, could still work from home on the basis of effective video conferencing and other platforms. The training could continue. So we have allowed that to carry on with the benefit, and I'll speak about that very shortly, the safety net of webinars, so that there could be online training in addition to the continuous training that they would have with their masters, albeit now from a work from home basis. The other aspect of the pupillage is that we require all our pupils to do a minimum of 14 days of pro bono legal aid training. In other words, they are actually attached to a legal aid center. They would do doc brief, or they would actually advise under the supervision of a senior lawyer. Now, that's because of the rich and strong culture, pro bono culture that we have in the Malaysian Bar. And it's something that we want to imbue in our pupils right from the day when they start training. And so that's something that's very important. So again, you'll imagine that was also interrupted. So what has happened now is instead of having them spread the 14 days over the 9 months, for most of them, we have put them on a fast-track basis of training so that they will still not lose that experience of pro bono work, which is critical in the earlier years of their training to become a lawyer. Those are just two aspects of protocols we put in place for pupils. In respect of lawyers, like other jurisdictions, we have a mandatory CPD scheme requiring members to acquire points over a CPD cycle. And in the past, these schemes were largely physical attendance at seminars, your experiential sort of learning, and the online teaching was actually the minimal part of it. But today, with all the SOPs in place, with the lockdown and the enduring pandemic, the bar has moved to actually have more online trainings. And we have had focused webinars, and I have it here on record, that since the shutdown from March to date, we have actually run a record of about 97 webinars, which I don't think we have ever done before, to deal as a safety net, both for our pupils as well as the lawyers, so that they could still participate in the CPD scheme. So there was no relaxation of the CPD scheme. There's no deduction of the points that lawyers are required to acquire, but instead, I think they've had the benefit of a very focused CPD scheme in areas like response to the disruption caused by the pandemic, mediation, for example, in the face of the pandemic, and how you familiarize with e-court procedures. So you have had that. And I think that is working quite well, and it really is one of the upticks. If there's anything positive about this pandemic, is I think we've now embraced a new way of training ourselves in the profession. Then there is, of course, the bar issuing guidance and guidelines on what we call business continuity plans. Nobody was prepared for this, as I said. So there was a need to actually guide on a step-by-step basis a real risk management protocol dealing with some of the most basic things that we take for granted. But because you took it for granted, you won't realize that you will actually trip up over it at this point in time when there's a shutdown and you're not able to function fully. We've actually gone into a very detailed sort of guidance system to guide lawyers so that they do not make any of those fundamental and basic mistakes. And then there is, after the lifting, and we are seeing the restriction movement in stages being lifted, not completely. We are still, in fact, as I speak, we are now facing third wave, which is not good, and we're having some lockdowns in particular areas. But there is, again, a very detailed guide that the bar has issued on how practices that had stopped would recommence, and what are the things, again, to look for when you recommence practice, with particular emphasis on health and safety protocols. Now, Malaysia's experience is actually not peculiar. I've heard experiences of other jurisdictions, for example, Bangladesh, probably one of the poorer jurisdictions in the Australasia region. Now they've actually moved in a very big way on online hearings, and that was preceded by detailed training given to the lawyers and judges as to how to handle online proceedings and advocacy online. And that is actually quite remarkable how in the past 6 months or so, they have really sped up in terms of their training, online training. Then there's the Law Society of Singapore, which has been very focused in dealing with issues resulting from the disruption caused by the pandemic. And indeed, they had a colloquium sometime in May this year where it was called the Role of Lawyers in the Age of Disruption, Emerging Regulatory Challenges. Very relevant, I think, to, in fact, the topics that we have today. Now, so if I may just conclude on the first part very quickly, what have we got here in terms of training protocols? I think we see a balance. It's not a complete waiver of compliance with training protocols, but there's some allowance for the interruption caused by the pandemic. It's not a lowering of standards of training, but I think the regulators, certainly in Malaysia and the Australasia region, have introduced an element of flexibility without compromising quality. And really what has happened also is, I think we have all used this opportunity to help our members to upskill and to, in many ways, reinvent the way they practice law. So that takes care of the first part of my presentation. The second part is really on financial assistance. The Malaysian Bar is actually, for a member of the Malaysian Bar, pays fees and levies because membership of the bar is compulsory for all lawyers in private practice in Malaysia. And that those fees and levies are paid like in any other jurisdiction on an annual basis. And obviously, because of the impact of the pandemic on legal practice, members face severe financial constraints. What the Bar Council has done is it has waived and reduced dues up to about 30% for members, which is a big sum for us, 30%. And even in the balance 70%, we have allowed members to pay over 2 tranches. And that is something I think that the Bar is still looking at and see how members are functioning, which is, I think, quite remarkable, given that we are non-profit organizations. We do not generate any form of profit, and we exist solely on membership dues. And I'm told that it actually has set back our revenues into many millions of ringgits, certainly up to probably $2 million, which is a big sum for us. And we've seen that sort of a direct financial assistance in other jurisdictions in the Australasia region. Certainly, the Law Society of Hong Kong has also given waivers and reductions. The Bar Council of Pakistan, another third world country, a poor third world country, but still reaching out to its members, and the bar and law societies across Australia. Singapore has done something rather novel. It has, apart from giving rebates on subscriptions, it has created what is called a compensation fund, or a compassion fund, a compassion fund, where lawyers and judges have been asked to contribute to these funds. And then through these funds, they make one-off financial aid to members of the bar and employees of law firms who are facing financial difficulties caused by the pandemic. Then there is, of course, indirect financial assistance. I think in most of our countries, there's this whole mosaic of financial assistance packages, which are confusing and not all together clear. The bar has been very proactive in collating the information, explaining that to members, so members can take the benefit of these schemes. Indeed, not only for members, also their employees. And I think one of this indirect financial assistance scheme that I wish to mention is the Law Tech Fund that was established by the Hong Kong SCR government. And the Law Society of Hong Kong, in their presentation to the CLA, have spoken very highly of that fund, which is really a fund to assist small and medium-sized law firms and barristers' chambers in Hong Kong to procure and to upgrade information technology systems. Now that fund is expected to benefit about 60% of the law firms in Hong Kong and 50% of the barristers' chambers in Hong Kong, which I think truly laudable that the government, together with the profession, has worked to help the lawyers in Hong Kong. So if I may conclude on this part, and indeed to conclude my presentation, I just wish to say this. If one looks at the challenges, of course, the daunting challenges that the regulators, the bar councils and law societies have faced throughout our regions, and certainly in Australasia and Malaysia. But what you see is regulators have been very alert and alive to the severe financial impact that has happened, that has occurred to the legal profession. And what we've seen is steps have been taken to alleviate this financial burden, albeit sometimes with very meager means on the side of the regulators. They may not have that kind of funds, but still, I think that has not stopped them from stepping up to assist in this difficult time. And that's really been a source of tremendous comfort to members, certainly in Malaysia, members of the bar in Malaysia, that you have our regulator concerned and looking towards how we would not really just, really to just survive to this time, this difficult time. And I think all that is quite laudable. I will conclude my remarks with that, Brian, and I'll be happy to take any questions after this. Thank you very much.
Well, thank you, Stephen. I mean, I must say it's absolutely fascinating from the comfort of our own offices to hear such a sweep internationally from Bangladesh and Pakistan to Singapore and Lesotho, not to mention Belfast and Toronto. So thank you, Stephen. The financial support, the stepping up, the responsibility of the regulator to act in support has prompted an initial question, which is from one of our audience. So Joseph Chiumiento, wherever Joseph is from, has raised an interesting question, which I would like perhaps Stanley to reflect on. And it is, we've heard about the regulators regulating the profession and the public interest and the protection of the public, but in the pandemic, has the focus shifted, do you think, from representing or advocating on behalf of the profession? And if so, are there special areas, Stanley, that you think the law societies should concentrate upon in their representations? Would you like to give some reflections on that question?
Thank you very much, Brian. So this indeed is very true of our part of the region, Sub-Saharan Africa, where a lot of what is happening now has got less to do with actual regulation, the regulatory framework, than the fight for survival, as it were, for most law societies. And I would give an example of the Law Society of Swaziland, which is formerly Swaziland, now Eswatini, where they were presented with a bill to replace the Law Society as it stands sometime last week, with a very short notice period of about 8 days running time, lead time, to give feedback on that bill by the Minister of Justice. Now, essentially, after some advocacy positions, she relented and has postponed the tabling of the bill. But why does this happen to law societies during a time of lockdown where you cannot meet as usually you can? The arrest and barring of legal practitioners during COVID lockdown regulations, where you realize that normally our advocacy strategies would be to go to court to show solidarity with a colleague who has been arrested, who has not yet been charged, and perhaps who has been arrested by 10, 20 policemen at their home, not summoned in the normal way through the law society or the professional bodies disciplinary committee, and you want to express solidarity, and the whole of the town is blockaded on the pretext of the COVID-19 regulations and the need to make sure that no one is moving around. So the ordinary tactics of it's not only the advocacy that we've shifted to, but we've had to evolve in our tactics of advocacy. And this is why you realize that yesterday we hosted a region-wide solidarity campaign. This was a virtual demonstration. We realized that we can't go on the streets, our voices being stifled, and we had to come up with new ways of advocacy. So by and large, definitely we've shifted from simply doing the regulatory and realizing that the regulatory is in inherent or imminent danger. And so advocacy has had to be stepped up in our region and in our part of the world. And before I just taper off this contribution, the most important part has been the gender-biased aspect of the attacks on the independence of the legal profession this side of the world, where the examples given were that in Tanzania, the judiciary, a panel of 3 men disbarred a female leader of the Bar Association. In Zimbabwe, similarly, again, a female leader disbarred. So this pattern keeps coming up where there is a bias towards a gender, misogynistic, so to speak, bias in the attacks on the legal profession. And you find that for the same transgressions, female leaders within the bar associations are getting harsh sentences that we believe are disproportionate. And this has been inimical to the professional interests, and obviously the fact that many other aspiring female lawyers who would go into positions of leadership are discouraged under such circumstances, and this concerns us. Thank you.
Thank you, Stanley. And I mean, I believe you have in mind Fatma and Beatrice in terms of the 2 lawyers that you referenced. Just on whether there's been a particular impact on the female lawyer as the only female on our panel. Teresa, do you have any sense of that experience in Toronto or in Ontario?
I don't, and I can't say that I know of anything in the way that Stanley speaks so powerfully about what's happening to female lawyers in his jurisdiction. So Stanley, I made a note of that to follow up. Thank you.
Can I pick up on the question from one of the audience members? Is there any particular matter that you think you would like to represent or advocate on behalf of members? Is it training? Is it financial need? I must say, Stephen has intrigued me by the Hong Kong Technology Fund, which seems to be a way of interesting government and matching a policy of technological improvement, but targeting it into law firms. So any reflections on where you would see the Law Society of Ontario advocating going forward, Teresa?
Well, we are looking at technology. We have a technology task force and looking at that specifically now. It's really trying to figure out the depth of what's happening to lawyers and paralegals in Ontario and how do we continue to support them through the myriad of ways that we've talked about. You know, mental health for me is a very big issue. When you take lawyers and paralegals and you lock them at home and tell them to work from home, and you know, these pressures and struggles with children, and you know, their schools were closed, so people were educating their kids at home and trying to work. There are so many pressures now on families, on lawyers and paralegals that I don't think we really fully understand. And then you add to that the financial pressures of, you know, your practice not working. So it's really a struggle to understand what's the best way that we as a regulator can help in all the different ways in which the pandemic is impacting on people, and we don't know the full extent of it.
Yeah.
So that's really a big struggle.
No, that's a good response. I want to try and bring all the panel in on this, David. I mean, it's a fairly free-flowing discussion that we're now in, so jump in.
Well, Joseph's question was about advocacy, pivoting towards an advocacy role, and I just wanted to say, you know, that's both proactive, where we've been engaging with government to try to explain the impact on our business sector and the importance of access to justice being sustained. We've heard a consistent theme this afternoon where lawyers and legal services were not regarded as an essential service, and we also encountered some ambiguity around that. So there was an important advocacy role in which all of us, I think, have participated in trying to explain why access to justice is an essential service. And then there's a sort of reactive aspect of advocacy, where I think all of us have identified what I sometimes describe as creeping authoritarianism. Now, it can be quite overt. I mean, we heard Stephen talk about movement control orders. We've heard Stanley talk about lockdowns that have, under the guise of public health, have also been a slightly nefarious way of refusing access to the courts for individual advocates. But even closer at home, we this week had cause, our president of our society had cause to speak out criticising our Prime Minister, who had spoken publicly at the party conference about what he called lefty lawyers, this unpleasant populist attack on lawyers who are advocating and representing, for example, people claiming refugee status, etc., have been twice this week, once by the Home Secretary in the United Kingdom and now by the Prime Minister, described as lefty lawyers. And our president thought it necessary to speak out and effectively said we really should expect better of our Prime Minister. This shaping the public narrative to regard lawyers who undertake to advocate on behalf of unpopular causes is a very insidious attack on the principle of the rule of law.
Thank you, David. Stephen, you might have a reflection from your own experience.
Yes, I just want to take off from where David left off. This is certainly not the time for bar councils and law societies, as occupied as they are dealing with the concerns of the pandemic, to take their foot off the pedal when it comes to rule of law challenges. Indeed, I think under the cover of the pandemic, we are seeing new challenges to the rule of law. Certainly, the pandemic has been exploited by governments, not necessarily just authoritarian governments who find it convenient to just use that as an excuse to get things done. So as busy as we may be, providing and I think dealing with the concerns of members, which is of course very important, we must not lose sight of this larger picture, because if that larger picture changes and things come into being, it's a bit too late then, everything comes to a halt in that way. So please be vigilant. I think it is important to be vigilant. It's important to speak out, and you may be accused of being insensitive. You may be told that these things are necessary, and you are just somebody who doesn't understand that it's necessary for survival. Yes, it is necessary, but it cannot be at the expense of principles that we hold dear, important principles. And access to justice is one of them. We of course speak very highly of the necessity of online hearings and things moving online. But let's also understand that there may be parts of our society who are not ready for that yet. And they may be in parts of the country where, for example, the infrastructure is not good enough for online hearing. Now, if you go full head on with that, without factoring in those problems, then that's a denial of access to justice, you know. When we are actually talking about, you know, you speak very highly that this is really access to justice, everybody can reach the court. Really? You can? How do you reach the court when you do not have the basic infrastructure to log on to a hearing, and you're left out because of that, and maybe even prejudicial orders are made against you? So let's be vigilant. You know, this is not the time for us, as busy as we are, to just be so preoccupied with those problems that we forget some of the fundamental things that we stand for as a profession, as a bar. And I think those principles are universal.
Thank you, Stephen. I'm keen to both keep to time, but I would like to get a view on another question that has come in from one of our Canadian colleagues. And I think it's just to reflect on, many have said that the pandemic has accelerated the use of technology. We're using Zoom almost as a, you know, who would ever go back to an old-fashioned conference call just with audio only? So are there elements of your response as regulators that are likely to prove permanent? Are there elements that we have in fact benefited from this acceleration that actually we're not going to return to the way we were in November 2019? Teresa, do you have a thought on the going back to this time last year, or have some things really changed forever, do you think?
I think some things have changed forever. The way in, exactly what you've said, the way in which we're meeting, some hearings, court hearings, tribunal hearings maybe have to be held in person. Others, there's a huge movement for efficiency reasons. Looking at licensees, do we have, you know, these huge halls where we have, you know, 600 people sitting and writing licensing exams anymore? Or is the move to online, which was forced upon us and which we adapted to, is that permanent? Work from home. What's going to happen to these office buildings? You know, I'm in downtown Toronto where there are, you know, skyscrapers everywhere. What's going to happen to them? And will there be that movement to more working at home? So I think there's lots of ways in which we've got to decide what we keep and what we go back to. But it really is the time for, you know, modernization and for thinking, like, as I said at the end of what I said, you know, how we're regulating, and should it be a different touch now rather than the same? And I think it really is time for something different.
Thanks, Teresa. David or Stephen or Stanley, on this question of what do you think is likely to remain, and what is there no going back to? David?
Maybe if I kicked off, I think participation in our society has also improved greatly. Attendance at events has increased considerably. And we, I think, will want to retain this flexibility. I think the days of expecting people to physically travel to our head office for a council meeting or a committee meeting are in the past. We were very Belfast-centric in Northern Ireland because that's where the greater part of the population would live, and many of the big offices. But it meant that we had a sort of two-speed profession. Those who were more physically remote, geographically remote, probably never thought of participating in the Society's organisation. And I think they will now see that there's no impediment to them if we're holding meetings on Zoom. I'm looking forward to our annual general meeting next month. I know, Brian, you'll be addressing it, and usually we address a room of about 30 or 40 people. It's with some trepidation that someone asked me recently, well, what sort of a license do you want for Zoom? I mean, how many 100 participants are you catering for? Well, that in principle is a good thing. It might be quite challenging, but it is a good thing, and it's profoundly democratic to open that up. Just another remark, I acknowledge Stephen's point that we need to make sure that we're moving at a pace that the infrastructure supports, and not every community will have good internet connectivity. But where it is available, such as in Northern Ireland, I'm disappointed that the courts administration and the judiciary are still trying to start up again a broken system, a system that was slow and not working particularly well. And this idea that success will be to start up a poor system that wasn't working well seems to me to set our sights too low. We should, just as we in our own discussion this afternoon have shared examples of where we have rapidly made progress and introduced new ways of working, I would like to think the courts could also reimagine what a court hearing would look like. At the minute, they're paralyzed by the fact that they can't physically bring everybody into the courtroom in some instances because the courtroom is too small. The answer, it seems to me, is not to get a bigger courtroom. The answer may be to do things differently, open it up to web-based participation. Not every hearing requires physical attendance, and we could get through a lot more if we were slightly more imaginative. So those were my thoughts, Brian.
Our Prime Minister suggested a big initiative of using wind power to power up the homes. Maybe we'll have wind powered, we'll all have little windmills on our desks to wind power the internet or something like that. But just as we gather some thoughts, I'm going to bring in both Stanley and Stephen on this question of, is it the correct ambition to go back to November, October 2019, and is that a success? Or in fact, as we emerge, do we have a vision of a new way of being regulated and of supporting our members? Stanley, you've unmuted, jump in, please.
Thank you. And so I take from what David said that what we have now is a new normal. And this new normal is going to obviously integrate the best parts of what we had before the new normal and what we are evolving into. And I'm very impressed with some of the law societies that I've spoken to that have said in their inspection for the opening of new law firms, they're now creating guidelines for IT and cybersecurity policies. And these are the new tools of trade that we need as opposed to space and so many square meters in the center of town, where the High Court used to legislate that you should be within 5 kilometers for you to deliver process. Some of these things now have to change, and we have to recognize that anybody from anywhere can electronically submit cases and process them without necessarily getting into court. And I think that obviously that speaks to the issue of admissibility of evidence, and that legislation must change into the future. I was impressed with also the mechanism to automatically, whilst you are actually in bed from one of the regulators that I spoke, to issue a temporary practicing certificate that immediately reflects on the database of the court so that a lawyer who has paid their licensing fees can access the court. This becomes very progressive as opposed to you depositing money and then getting your physical practicing certificate posted to you. And during that time, you've got a letter that sometimes the court accepts or doesn't accept, and this can ruin your reputation as a legal practitioner. So I think we are rethinking the new normal. And I think working from home is not at all bad. It's flexible and gives you more time, less overheads from transport and going through all the transport traffic jams and so forth. So I've done my reflection, and I really think the new normal is the way to go, and the world might really never be the same again.
I think you're right, Stanley. Stephen, I often turn to you for a general summing up as our excellent Vice President for Australasia. I just want to acknowledge a question or an observation made by the Sabah Law Society that seems to be heading towards a lockdown, and to reassure the jurisdictions listening from the Commonwealth that the CLA can issue statements of support and please join up and participate in our work. But some closing reflections, Stephen, before I wind up and let everybody get on with their day or into their evening or whatever they're planning to do. Stephen.
Very briefly, Brian, it's just this. I think we are going to have moving forward a mixture of the past and the present. I don't think we can completely discard what we have done in the past, and that's really the nature of the legal profession itself. We don't really overnight modernize, and let's get real. We are going to get back to some of those practices where we can, but we have certainly seen the benefits of it, And in terms of financial impact, and I think that's something that has been, if you like the thread that's been running through everything that we have spoken, because we don't really know what the financial impact is on the legal profession in any of our jurisdictions. I think we're only seeing the tip of the iceberg, if you like, and that's going to be long lasting. Now, we have to deal with that. Now, to deal with that means dealing with cost. And when it's technology, and when technology is properly managed and when it's fairly imposed, then cost can be brought down. You can reduce cost. An example of that is the Bar Council of Malaysia. For many years in the past, when we had to renew our practicing certificates, it was a laborious process. It was a laborious, highly document-heavy process. But we were a bit ahead of time, because I think it was in 2017 that we put in place a completely technology, IT-based renewal of our practicing certificates, annual practicing certificates. What took months now got done in a matter of days. And so we saw the benefit of that, saving to cost to the regulators, saving the cost to the members who are caught in this. And so that's there. And you're also seeing what's happening in the courts. And David is right, we shouldn't actually jump into it, but there are benefits in it. If you look in terms of hearings, which could be conducted now almost paperless, and that's really been a move again as part of online and IT, so paperless hearings, which means, you don't need to be chopping so many trees. For goodness sake, bundles and bundles of documents in court. It's difficult for us, it's not easy for the advocates on the field, because we are used to having our hard copies with us, but we are learning. So we see, I think, Brian, if I may just conclude by saying this, I don't think we're going to discard everything from the past, but we have seen a lot of things in the last 6 months, which I think will guide us as to how we can integrate the past with the future in this, what we call the new normal. Thank you.
Fantastic, Stephen. Thank you. Thank you so much. And thank you, all of our truly brilliant panelists. One of the things, of course, that this method of connecting with each other lacks is the spontaneous round of applause that would erupt at the conclusion of a session such as this. And I think you should all hear the warmth and loudness and unstopping nature of the applause ringing in your ears, because I've enjoyed that. I'm sure those listening have enjoyed it, and I'm sure those listening in on the recorded version have enjoyed it. So it really falls to me simply to draw this webinar to a close. I thank the Canadian sub-hub of the Commonwealth Lawyers Association Hub of the Americas. I thank our participants for preparing, for giving of their time and sharing so candidly of their views. I have some memorable takeaways, but I will give Teresa's different touch my valedictory thumbs up as a phrase to take forward. And really, I look forward to many listening. If you're not already CLA members, well, join up, see what you can participate in, and get this range of international views brought to you. Take an interest in our conference in September, a year from now, in the Bahamas, where the theme is sustainable justice. And how do we sustain justice in these challenging times? And that embraces environmental issues, training issues, access to justice issues, and we've got a really thrilling program for us all. But for now, I say thank you, Teresa, thank you, David, thank you, Stephen, thank you, Stanley. It's really great to see you. And I hope that my instruction now to our Bridget and her team handling the technology will close the webinar for everyone else and stop the recording. And I wish everybody well for the rest of your day. Thank you.